Businesses without their own IT teams may wish to outsource the creation, design, and development of their website to external developers. Web development agreements are an understanding of expectations between businesses and web developers. These agreements usually include a written specification of what is to be delivered, service levels, and a timetable. There should be an agreement on pricing, payment, and acknowledgement of intellectual property rights. Warranties, limitations, and exclusion of liabilities are essential to the agreement in order to apportion risk so that if any problems occur, both customer and vendor are aware of their rights. And finally, there should be a dispute resolution mechanism and provisions for termination and change control. Terms of use agreements are commonly found on websites and are intended to regulate and impose conditions on the access and use of the website. They set out the user's rights, obligations, and responsibilities when accessing the site. It is important to have terms relating to intellectual property rights and limitations of the website owner's liabilities. There will also be representations and warranties by the user. Finally, there should be a clause that determines how any dispute is to be resolved and the choice of law to govern legal proceedings. A common method of concluding contracts online is by clicking to indicate one's acceptance. These are commonly referred to as click-wrap agreements. Another means of concluding a contract online is where the terms and conditions are posted on the website and the user is told to refer to it, with no requirement that users take any affirmative action to indicate their assent. These are commonly referred to as browse wrap agreements. Such agreements ensure that the terms and conditions are clearly brought to the user's attention and notice. They prevent any access and use of their website until the user has indicated their assent to be bound by the terms and conditions. Or they require the users to scroll through the terms and conditions in their entirety before allowing the users to give their assent. Two things that are crucial to establishing an online presence is the domain name and the trademark. These are the means by which the public identifies your business. A domain name is the online equivalent of a street address or a telephone number, and it's the means by which people are able to remember and access your website. Once a domain name is occupied, other parties will not be able to use it. Therefore, it is imperative that once a preferred domain name is chosen, the business should acquire it as soon as possible. Trademarks are signs such as logos and images that businesses can use to indicate that a particular product or service belongs uniquely to them and to distinguish their products or services from other businesses. Businesses should register their trademarks to enjoy a monopoly over its use and to prevent others from using them without consent. Digital signatures are used to establish the identity of a party, to make legal commitments, or to guarantee that the contents of a file or message have not been altered. For a digital signature to work, a trusted third party, known as a certification authority, is required to issue digital certificates that verify the electronic identities of users and organizations. The certification authority acts like a trusted electronic notary, letting people know who the valid users are, along with their corresponding digital signatures. With a certified electronic identity, an internet user's digital signature will then be recognized by parties involved in electronic transactions like internet banking, online shopping, and online information subscription services. Another means of keeping transactions secure is through the use of encryption key pairs or EKP. Encryption is a mechanism by which messages or information is encoded in such a way so that only authorized parties who have the key can decrypt the message and read its contents. Using an EKP, the terms of the transaction can be negotiated in a secure manner by by parties who each have the key. Once the terms are agreed, the parties can then sign the contract with their digital signatures. With the e-commerce or m-commerce business, the proprietor is inevitably going to come into contact with or possess personal data belonging to individuals. This may occur when customers provide contact or personal information when placing an order or when signing up for an account with the online business store. The recently enacted Personal Data Protection Act sets out a baseline standard of protection for personal data. All organizations must comply with it when collecting, using, disclosing, or processing personal data. Businesses should ensure that they comply with their obligations when handling the personal data of their customers. Failure to do so may result in enforcement action being taken against the business by the Personal Data Protection Commission or private action being taken by the individual. Under the Personal Data Protection Act, businesses that collect, use, disclose, or process personal data are required to make certain information regarding its data protection policies and practices available to the public and on request. Such information includes information relating to the business's data protection policies and practices, the process for receiving and responding to personal data related complaints, and finally, the contact details of the data protection officer. In light of this, businesses are encouraged to establish privacy policies on their website containing this information.